Welcome, everyone. Thank you for joining us again today. We have a full lineup, so I will get started now by going over the agenda and introducing our panelists. First up today, we have Jason Kaufman from our New York City office. Jason is going to discuss an expansion on scheduling and workplace protections for service and delivery workers in New York City. We will then have Samuel Wiles, also from our New York City office. Sam is going to provide us with an update on New York City's new pay equity reporting law. And then last but certainly not least, we have Lyndon Hall from our Syracuse office, who will be discussing some updates and continuing complexities of the New York State Minority and Women-Owned Business Enterprise Program. Okay, I will now turn the program over to Jason. Jason?
Thank you, Carrie. Hello, everyone. Thank you for joining us today. As Carrie mentioned, my name is Jason Kaufman. I'm a partner in Bond's New York City office in the Litigation and Labor and Employment departments. And I want to chat with you and give you a brief overview of some updates to New York City's workplace scheduling laws, particularly as they apply to three specific industries: the fast food industry, the retail industry, and the ever-growing app-based delivery industry. The law specifically is the New York City Fair Workweek Law, and it carries meaningful compliance obligations for employers and the risk of significant penalties if overlooked. So generally, this law is, the purpose of this law is to provide workers in these spaces with predictable scheduling and advance notice of their shift, so that they can better manage their lives with respect to childcare, school, and other life responsibilities. So the first industry affected by New York City's Fair Workweek Law is for fast food employers, and there are several key requirements. The first of which is that employees must receive a regular schedule that shows their expected workday and hours. These work schedules must be posted and distributed 14 days in advance, not just in a break room, but directly to the employees, such as email, text, or a scheduling app. If an employer needs to make a scheduling change, it must be communicated in writing as soon as possible, and again, posted and individually sent to the affected employee. Importantly, employers for fast food employers must pay a premium compensation for certain last-minute scheduling changes. So depending on the timing and the impact of the change, these premiums can range from $10 to $75 per change. So it's not insignificant. Lastly, there is a $100 premium required for what's commonly referred to as a clopening shift, closing and opening, where the employee closes late at night and then returns early the next morning to open. So a change in that shift requires a $100 premium. The next industry that is impacted by the New York City Fair Workweek Law is retail employers, but they're covered by a slightly different set of rules. First, the schedules must be provided to these employees 72 hours in advance. Again, same as fast food, both posted directly and distributed. Employers cannot add or cancel shifts within that 72-hour window without the employee's written consent, so a nuance there. And unlike fast food, retail employers are prohibited from using on-call scheduling. This means that requiring employees to be available to work without guaranteeing a shift. Again, violations can lead to fines of up to $300 per affected employee, with higher penalties for repeat conduct. The next industry affected is the ever-growing delivery workers industry, which is a very, very important to New York City. And it has led the country in setting minimum pay standards and working conditions. The city recently extended these protections to grocery delivery workers after the city council overrode the mayor's veto. The minimum pay rate is currently $21.44 per hour, and delivery platforms are required to provide the following for their drivers or bicyclists: provide insulated delivery bags, improve bathroom access, and offer greater transparency regarding tip and pay calculations. employers, or generally we counsel employers to keep their records for up to 6 years. In the setting in which an employee has claimed a violation of this law and the employer does not have the records, the law presumes that the employee is correct in any dispute. So from a best practice standpoint, and consistent with our counseling on wage and hour requirements generally, employers should consider maintaining records for 6 years. So what does this all mean for employers? The law signals an ongoing emphasis on predictability, fair scheduling, and transparency of wages. So employers in these spaces should take proactive compliance steps, including reviewing their scheduling policies, training managers so that they understand when premium pay is required and what practices like on-call scheduling are prohibited, and confirming that your record keeping systems meet the city's retention standards. Non-compliance can lead to not just civil penalties, but also private litigation. So this law has some teeth. The bottom line is it's here to stay, and it's actively being enforced. So compliance requires from the employer side, both policy updates and day-to-day managerial awareness. If you have any questions, you should reach out to your contact at Bond, or you can reach out to me directly and we can discuss strategies, how to best protect your business if you are one of the industries affected by this law.
Great. Thank you, Jason. We appreciate your update. I will now turn the program over to Sam. Sam?
Good afternoon, everyone, and happy Election Day. So I am covering 2 bills recently passed by the New York City Council. And before I get into that, we'll do a little bit of Schoolhouse Rock of how a bill becomes a law in New York City. So this is relevant, even though these bills haven't been signed into law yet, because they passed with overwhelming support and a veto-proof majority in the New York City Council. So these bills relate to pay equity reporting, and a report that the city is to complete following submission of reports by employers. Right now it's sitting on the mayor's desk and has been sitting there since October 9th. He has not signed it into law, but once a bill has been passed by the council, it's presented to the mayor. If he does not sign or veto the bill within 30 days or takes no action on it, then it will automatically become law. If he vetoes it, it goes back to the city council where it has a chance to be overridden. So right now, the bill is currently sitting with Mayor Adams, so we'll see what happens with it. But I think employers should anticipate that the bills I'm about to describe will become law at some point in the near future. So the first bill is INT number 982-A. This requires employers to submit a pay equity report annually. The report would include demographic information and occupational information in connection with employee pay. These reports will be fileable electronically after proper agency is determined to create the report. So this report would cover employers who employ more than 200 or more employees. The bill defines employees as those who are, quote, employed for hire within the city of New York. And it is determined by counting the highest total number of employees concurrently employed at any point during the reporting year. The report will require the mayor to designate an appropriate city agency to develop a form for employers to complete. The city will allow employers to submit the information anonymously. And upon submitting the required data, employers must also sign a statement certifying the accuracy of the information contained in the report, but that also must identify the employer. Law isn't without teeth. Employers who fail to comply with the bill's requirement would be subject to steadily escalating penalties. So while the first offense can be remedied within 30 days after a summons or notice indicating non-compliance, if the employer does not remedy the violation, it would be subject to an initial civil penalty of $1,000. For each subsequent violation, it would be $5,000. and it doesn't appear that there is a cap on the number of subsequent violations an employer can incur. So these bills would all take place, assuming after they are passed, the agency would have a year to develop the form and indicate. So it wouldn't be anything that would have to be implemented the next day, but employers should be aware of this and should be in the process of maintaining and preparing their data. The second bill would works in tandem with this, and it's INT number 984-A, and it requires the mayor to designate an agency to create a pay equity study no later than 1 year after employers submit their reports, and then this would be an annual report going forward. The bill requires that the study must be used to evaluate the data from the pay reports that the employers submit, and the purpose of this is to assess pay disparities in compensation based on gender, race, or ethnicity, to help identify prevalent industries with disparities, or to track trends in occupational segregation. Moreover, the report would be done in a manner that does not reveal any information about any particular employer or employees identifying information. So overall, I think employers can view this in a way that is part of a series with New York City and requiring bills that create greater transparency in pay. New York City and New York State already have bills that require employers to publish salary ranges and job advertisements. This is just the next step in that. So again, employers should expect these bills to pass in one way or another, whether in the next administration, whether through veto or override. But employers should also expect that this will add administrative obligations and record-keeping obligations. Like Jason said, in regard to other obligations, employers should already be maintaining records for at least a period of 6 years. But this will just be another item for employers to watch. So I think going forward, again, like Jason was saying, if you have any questions, feel free to reach out to your bond contact or me. We're always happy to discuss. But thank you all for your time and attending our webinar this week.
Thanks, Sam. Just to clarify, do both bills only apply to employers with 200 or more employees working in New York City? I think you mentioned that with respect to the first bill. I was just curious about the second, if you know.
No, the second bill is only about creating the study. So it creates a study from the data that the employers submit. So only employers with 200 or more employees would be required to submit reports. So it would be based on those larger employers. And a thing to note is, when I was looking into this, a prior version of the bill wanted this information from smaller employers, meaning those with 25 or more employees. Now it's up to 200. So it is, taken away from those smaller employers, but it still could be an issue for employers who it doesn't address joint employer issues. The bill doesn't. It just defines employer as it does in the New York labor law. But for those employers who have, maybe more transitory workforces or seasonal workforces or workforces that might ebb and swell throughout the year, if your workforce hits 200 at any given point in the year, then you'd be subject to this pay reporting. So, this might be catering companies, it might be seasonal companies, those companies that might have larger workforces at different times of the year. So just that's probably the employers who might have more trouble managing these new obligations.
Great, thanks. Yeah, that's really helpful clarification. Perfect.
No
Okay, thank you. Moving right along, we will turn the program over to Lyndon for her presentation. Lyndon?
Hi, everyone. My name is Lyndon. I am an attorney with the Tax and Business Department here in Syracuse, and I'll be discussing the Minority and Women-Owned Businesses Enterprise Program today. Next slide, please. So overall, there hasn't been too many changes, but on May 9, New York State passed legislation to modify some of the program requirements. The eligibility criteria and the core requirements remain largely unchanged, and these updates are kind of just to ensure support and continued items to be updated so that the women and minority-owned businesses can continue to have a fair shot at these contracts. The certification process itself is done through the Empire State Development Division of Minority and Women's Businesses Development Division, and nothing has changed there. So the actual certification application process is still completed through there. Next slide, please. So just as a general reminder, these are a few of the eligibility requirements for certification. So there has to be a majority ownership by minority or women owners. This means that that owner holds a meaningful percent of the business, that they have invested a substantial capital contribution, and that they share in the risks and profits of the enterprise. There also has to be active involvement by the applicant. So the owner has to be a minority or woman owner that has relevant experience in the industry, has operational decision-making authority, and actually spends a personal amount of time devoted to running the business. So for example, a minority owner of a construction firm will have 15 years of experience in business, might oversee a project bid, and works full-time managing the crews and client relationships. Then for control, to qualify, the minority group members or women have to demonstrate control over day-to-day management. So this prevents hiring someone to do this and putting it under someone else's name and just have the minority or women-owned business owner on the deeds. And then you also have to have the authority in business negotiations to make decisions and sign the paperwork to bind the business. And one of the final ones is independence. So the division is actually going to assess whether the business operates independently, seeing whether it shares resources, if it conducts most of its business with a single client or partner, or whether it benefits from any affiliations that are consistent with the industry practices. And again, this is just making sure that someone doesn't open a business and call themselves an MWBE, but actually has someone else running the business. And the state is very stringent and looks into all of these. So it's very important to make sure that your business is meeting these. Next slide, please. With all those requirements said, even if the business does meet the requirements, there's limitations that the businesses should keep in mind. So there's a personal net worth cap, meaning the owner has to have a net worth below $15 million, and that will be adjusted for inflation moving forward per year. It has to be a small business enterprise, so that means it has to have less or no more than 300 employees averaged over the last 4 quarters of the business in which the application is filed. And then you cannot apply for this designation until your business has been operational at least 1 year in New York State. And in addition to that, you have to be authorized in New York State to do business and actually actively conducting business within New York State. Next slide, please. Thank you. So as noted, the actual key updates don't change too much of the certification process. They are kind of enacted as part of KK of the fiscal year 2025-2026 budget bill, and it preserved all existing rules governing eligibility, certification, participation. One of the main ones is that it extended the timeline. It was originally supposed to sunset in 2025, but now this program is going to be extended through July 1st, 2028. There is also a higher discretionary purchase threshold. So it went from $750,000 to $1.5 million. That allows agencies to award contracts without formal bidding and allow more MWBEs to be able to obtain these contracts in comparison. And then next slide, please. The state also wants to maintain transparency and keep reports on how many MWBEs are getting contracts. So they installed annual reporting requirements. So these will be detailed reports from everything from the exact minority groups, how many women-owned businesses are getting contracts, and they will be available to view in 2027. And they'll have comparisons to the prior years as well. And next slide, please. And so maintaining certification with these new updates, it's important to just maintain consistency and review the applications moving forward. Stay informed on updates. Now that we have this, we're not anticipating too many more updates, but Bond will continue monitoring in case anything else changes. And as always, Bond is here if you have any questions regarding MWBE or if you are eligible for the certification. You can reach out to me or the attorney that you're in contact with at Bond. Thank you.
Thank you, Lyndon. Well, that's all we have for today. We don't have any unanswered questions in the Q&A, so we will wrap up a little early. Thanks everyone for tuning in to the webinar. As always, we have the contact information for all of today's presenters on the screen. Please feel free to contact any of us with any questions. We will be back again next Tuesday, November 11th. Please join us if you're able to do so. Have a great rest of your day.